Hey everyone, this is attorney Elizabeth Potts Weinstein, and today I'm going to show you how to reply to an office action from the United States Patent and Trademark Office about your trademark application. Now, this one is actually really one of the most simple office actions, but since this comes up so often, I think it's a really good example, and you're going to be actually filing it with me because I'm replying to an office action on a trademark that I filed on behalf of one of my other businesses, Elizabeth Off Grid. Okay. So this is what you get. You get an email from them that says in the subject, it has the name, the number of your trademark and the name of it. And then it will be a courtesy email letting you know that there is a notice or office action. You don't get emails like this just for office actions. It can also be for other things that have happened in your account, but this is the way it looks. Then you have to click on this in the TDSR and find your trademark to download the office action. It's not attached to this email. So let's go ahead and do this. All right, so the serial number, I'm going to copy it. I'm going to go over to TSDR, paste my serial number in there and hit status. And now you can see what is in the account, that a non-final office action has been sent. So what an office action is any formal notice from the trademark office that there's some problem with your trademark. Sometimes they actually just email you. Sometimes they don't do a formal office action, but sometimes they do. It really depends on the examiner and what the issue is. So this was sent in September. Right now it is November. So you go over to the Documents tab, and this is where you can click on it and it'll pull up a PDF that you can download. I, of course, have downloaded this a while ago, but I'm just showing you how it works. It looks like an email that they should have sent as an attachment, but they don't send an attachment. So here we are. All right. So we'll have the information about what your trademark is, what your correspondence address is, and then it'll go into the actual information about the trademark. Okay. So first it says when this was issued and when the deadline is. So under the current rules, you have 3 months to reply. So September, October, November, December. So I have until the day after Christmas to reply to this. But I can get another 3-month extension. For this, I would not need that. But let's say you need to do more research, you need to hire a lawyer, whatever, you may need another 3 months. Now, I can actually just email the trademark examining attorney to resolve the issue because this is such a simple thing. I'm actually not going to do that, even though normally I would totally do that. But the reason is kind of want to show you what responding to an office action is like. Okay, so the reference application has been reviewed. They found no conflicting marks. That's great because that's the thing that would be the hardest thing to deal with. But it says I need to have a disclaimer. Okay, so this trademark is Elizabeth Off Grid. So I have to disclaim the phrase off grid because it is merely descriptive of something that I'm doing. What they do is they attach evidence, which is from a dictionary. This is a very common thing that they do is attach evidence from a dictionary, and it's defining the word or the phrase, I guess, off grid as being not connected to or served by publicly or privately managed utilities such as electricity, gas, or water. And then since my services, which is a YouTube channel, is related to living without publicly or privately managed utilities, then I need to disclaim this. Okay, so here's the thing. Should you agree to a disclaimer? I would say usually yes, but not always. Sometimes they're wanting you to disclaim a word that you're actually not using in the ordinary way. And it's kind of like the phrase that you're doing is this clever little turn of phrase. And so you shouldn't have to disclaim any of the words. Most of the time, it's not true. Most of the time, I'm disclaiming usually things like the word coaching or the word system or, something that's just a generic word that has no kind of trademarkiness about it. Now, in this case, there's an argument that I'm using it in a clever way, but really the most important thing here is the word Elizabeth. Because here's the thing, is that if someone else made another YouTube channel that was Rebecca Off Grid, I'm not going to sue them for trademark infringement. They probably came up with that completely independently because this isn't like the most clever thing ever that I came up with, okay? And I don't think anyone would think that Rebecca Off Grid is me because I'm Elizabeth. So that's different. You understand what I'm saying here? The off grid is not the important thing here. And also it doesn't have to be Elizabeth Off Grid. It's the Elizabeth part. That's what my thought is. there's lawyers who are more hardcore about this and will argue this point with them, but I personally don't. So to respond, I could have sent an email, which normally I would, but I'm wanting to actually file a formal response so I can record it for you all. Okay, so how do you respond to this? Then you use the form, okay? Or do extension of time. Then there's always the name of the trademark examining attorney, and you can actually email them here, okay? One thing to note is if you send them an email, the email becomes part of the record, okay? So be aware of what you're sending in the email, knowing that's going to be in the publicly available database, all right? Also, the email address you use is the publicly available database. Another thing I wanted to bring up is when I got this, and over the last 2.5 months, I have gotten so many unsolicited, in my opinion, spam emails from lawyers seeing if they could help me with responding to this. It's been so annoying to me, okay? Now, maybe some of those lawyers are good, I don't know, but I don't think it's cool for them to just be spamming people who get an office action. But here we are. So after this letter is done, then it has a whole bunch of like dictionary definitions, effectively, of the word phrase off grid. And then here's the notice that they sent to me. All right, so let's actually go and see where you actually respond to this. All right, so you go to the trademark website, and then you go to the apply online. And I know it doesn't make sense because that's where you applied for the trademark, but this has links to every single form that you may ever need to file about your trademark. So you go to response forms, response to examining attorney office action form. And then you have to log in. So you probably created a login when you filed your trademark. So this is the same thing you're going to use here. So I'm going to go ahead and do that. Okay, so I've logged in, and now you go to the form response to office action. And the first thing you need to do is put the serial number of your trademark application in there. So I'm going to go ahead and paste that in. When you do that, it should pull up your file once it thinks about it for a little bit, apparently. Okay, so you want to look and make sure this is the right one. You didn't mistype it or anything like that. Okay, great. It's all correct. So what do you need to do? Do you need to respond to any of these? Likely to cause confusion, merely descriptive, any of these things. These are more like complicated things to respond to. Then you click yes, and then it would take you to screens about that. Do you need to do any of these things? Change, modify your identification of goods and services, which is your class stuff, any of those kind of things. Submit a new or substitute specimen. These are common things I have to do for clients because sometimes the examiner doesn't like exactly the way I phrased a class description, or the specimen we submitted, there's something like some minor error with it. So I commonly will have to do one of these. This is the one that I'm doing here, is just a disclaimer. So disclaimers, colors as a feature of a mark, which is if you do a logo, claim of power registration, consent to register the name. I actually already did that because my name Elizabeth is in it. And then new drawing of the mark. This is typically if you're filing on like your logo or something, there's some error with the mark. Correct or change the owner's name or entity information. So this is where you'd fix this if you like made some typo, or something like that. You didn't it's not a new owner. It's just like there's an error in it. And so, yeah, a bunch of other things, different fees, different attorney, you need to have a signed declaration, etc. All right, so let's go over here to disclaimer and click yes. Whenever yes you click, it will dynamically generate different screens. All right, disclaimer, no claim is made exclusive use, the right to use. All right, so this is where you go back to your office action. You go back to your office action and find exactly what they want you to put in there. And you cut and paste it. So there you go. Okay, there's all this other stuff that I don't need. This miscellaneous statement you don't really want to use unless it seriously applies, because it'll kind of make everything take longer. All right, it's going to show you the correspondence information again, and then you sign this. All right, so I am an owner who's not represented by an attorney, even though I am an attorney. I know it's kind of weird, but and then you go ahead and sign owner, validate it. And then I always right click on input, open that up into a new tab, and check to make sure it's right. Okay, this is all right. And then this is what I wanted to do. Then go back to the tab I was on. You always have to click this, this is like all the things that you are agreeing to, that you're swearing. And then submit. Yay. Okay. Then you save this and just keep that in your file. It will take a few days for it to show up in TSDR, and then hopefully they'll get back to you in a month or two. It really just depends on how far back they are. I've actually found this like the day before Thanksgiving. So they typically are slow around the Thanksgiving, winter, holidays, and all that stuff. But they're actually very far behind anyway. So who knows how long this will take. It would not surprise me for it to take a month or two. This is attorney Elizabeth Potts Weinstein. If you have an office action that you're trying to reply to, feel free to ask a question about it in the comments below. I'll try to point you in the right direction. Some office actions are much more complicated to reply to than others. So it is definitely true that the more complicated ones, like trying to overcome an objection about being merely descriptive, trying to overcome an objection of being confusing with another trademark, these are things that you really might need a lawyer to help you with, because you'll have to make legal arguments. Okay, like read a brief, right? And they're much harder to do if you don't have a legal background. But some things like filing a disclaimer is really more just about filing a form. You have to think about whether or not it's applicable in your situation. And if you want to not file a disclaimer, you may need a lawyer to help you come up with legal arguments to substantiate that. However, some of this is stuff that you could do. All right, thumbs up if you found this video helpful. Subscribe for more videos like this. See you next time. Bye-bye.